Hello everyone, I'm Leonard French, your favorite Hawaiian shirt-wearing copyright attorney, and tonight I thought I would talk to you about a recent trademark ruling by the Trademark Trial and Appeals Board, which this is a fairly interesting case, and I thought maybe everyone would have kind of a lighter Sunday with the Margaritaville Enterprises versus Rachel A. Bevis Trademark Trial and Appeal Board case. Alright, I guess before I should start, I know we've had some technical difficulties on these things. Can everybody hear me? Is there any echo? And do I have any hidden pop-up windows in the back that are playing anything from when I started the stream? I don't think so. So, okay. So somebody on chat let me know if there's a problem. So this just came out on March 16th. I didn't know anything about this. I just was reading through the weekend news and decided this might be a good topic for a video and maybe a good no echo, no extra noise. Great. So then we'll hear as the snow falls off my roof. If you hear any loud crashing, I don't think that's me getting swatted. I think that's the snow falling off my roof. So let's make this a little larger. So once again, this is Margaritaville Enterprises versus Rachel A. Bevis in the United States Patent and Trademark Office. These sorts of things are... So I've got this is cool now, right? These sorts of things are not adjudicated by a traditional court, and instead there is a Trademark Trials and Appeals Board that hears these things in Washington, D.C. They can go to a higher court on appeal if they have to. So this was just heard on February 28th. There was a hearing. It looks like the defendant, Rachel Bevis, Rachel? Let me turn off the clicky thing on my mouse. Rachel Bevis was represented by legal counsel, but then chose to represent herself. While acknowledging that the parties may appear pro se, the board advised applicant to secure the services of an attorney familiar with the board inter partes proceedings. So they advised her right away that she shouldn't really be doing this without an attorney. So let's keep this in mind and take everything with a grain of salt when we go through this. I think you'll see some things. Rachel Bevis has applied to register the trademark Marijuanaville in standard characters on the principal register for t-shirts, hats, sweatshirts, sweatpants, jackets, socks in International Class 25 and drive-through retail store services featuring coffee and related goods, retail apparel stores, and retail clothing stores in International Class 35. In case you're wondering what international classes are for search and archival purposes, you have to, also because it's a big part of trademark law, you have to categorize your trademark, and your trademark only applies within the categories that you have received a trademark for, that you're actually doing business in, and then those that you might reasonably expand in. And there's a whole lot of law there, so that's going to get more complicated than even I understand, because I am a copyright lawyer, not a trademark lawyer. Margaritaville Enterprises, known as the opposer, opposed the registration of applicant's mark on the ground of likelihood of confusion under Section 2D of the Trademark Act, based on opposer's previously used and registered Margaritaville marks. Opposer pleaded ownership of and submitted with its notices and opposition copies of multiple pleaded registrations obtained from the USPTO, including the following: registration number yada yada for Margaritaville, in typed format and on the principal register for clothing, namely shirts, sweaters, sun visors, and caps, in International Class 25, and nightclub services, retail clothing, gift and souvenir store services, mail order services in the field of clothing, gifts, and souvenirs in International Class 42. So those are some pretty similar things, right? So if these overlap, then we've got a problem. And another registration for clothing, namely pants, sweatshirts, shorts, and dresses in International Class 25. In her amended operative answer to the notice of opposition, applicant denied, and remember the applicant is Rachel Bevis, is not Margaritaville. Applicant is Marijuanaville. Applicant denied the salient allegations, meaning that she denied the meaningful allegations. In her answer to the notice of opposition, filed approximately 3 months later, the then pro se applicant, representing herself, admitted several salient allegations, including the following: that Jimmy Buffett is an internationally famed musician, that Margaritaville is the successor in interest to trademarks filed and registered by Mr. Buffett, that Margaritaville provides goods and services associated with Jimmy Buffett, that Margaritaville regularly commercializes Jimmy Buffett song titles, that Margaritaville coined the term based on his famous song Margaritaville, and that due to long-standing and widespread use of the trademark, the mark is associated strongly with Margaritaville and Jimmy Buffett, that the mark has been used on a wide variety of goods and services for many years. Pardon me while I take a drink. And as a result, the mark is commercially strong indicator, a commercially strong source indicator for Margaritaville's various goods and services. Now remember, trademarks are important because they not only are a corporation's branding, but they're also the consumer's safety of knowing the source of the goods. So that's what they mean when it's a strong source indicator. It means that when you see the Margaritaville brand, you know it's associated with Jimmy Buffett and his chain or the chain of restaurants and other products that he's authorized. By virtue of Margaritaville's continuous and exclusive and widespread use of the distinctive Margaritaville mark, Margaritaville is entitled to a broad scope of protection, and Marijuanaville and Margaritaville share the same first and last 6 letters and are similar in appearance. The remaining salient allegations were denied. The board denied opposers' fully briefed motion for summary judgment, and instead the parties stipulated to resolve the matter under the board's accelerated case resolution procedure, which seems to be some kind of like arbitration or mediation. You can look it up yourself if you want under this trademark trial and appeal board procedure manual. The parties are commended for pursuing this expeditious, cost-efficient alternative to trial. In lieu of separate assigned testimony and briefing periods, the parties agreed to treat the summary judgment motion evidence as part of the final record with the option of filing supplemental briefs in summary judgment format with additional evidentiary submissions attached thereto. So they did a different procedure for this, probably to save money. The record includes the pleadings and, pursuant to the trademark rules, the application file. Opposers submitted with its motion the following evidence: the declaration of a paralegal employed by one of the attorneys, and opposers submitted a declaration of Jimmy Buffett, a chief financial officer, a chief legal officer, a chief marketing officer, a marketing consultant, a lexicographer and linguistic consultant, a singer-songwriter, and Mary Martha Adkins. Applicant did not make any evidence of record. Now that's weird. That means that the applicant, the pro se applicant, didn't really present any evidence to the contrary. So to me that says maybe the board didn't have much of a choice but to grant this opposition if the evidence that they have shows anything at all. But it does. I mean, it's you're going to see that. That's pretty clear. But why? Why is the fun part? Standing. Standing is a threshold issue, must be proven, yada, yada, yada. We're going to skip this. There is no question that the parties have standing between the applicant filing the mark and Jimmy Buffett owning Margaritaville or having assigned Margaritaville. So we're going to skip to the trademark claim. We will now consider opposer's Section 2D claim, focusing on opposer's registered mark Margaritaville. for the goods and services identified in the registrations made of record, yada yada. In our view, these two registrations, coupled with their corresponding identified goods and services, are most likely to support a likelihood of confusion claim. If a poser could prevail on its Section 2D claim on those registrations, then consideration of the others is unnecessary or moot. Priority is not at issue in view of a poser's ownership. In other words, one trademark doesn't have priority over the other. The Margaritaville trademark is being applied for, or Margaritaville trademark was applied for in 1979, I believe, and the Marijuanaville is a brand new application. Likelihood of confusion is the standard of trademark. We base our determination under Section 2D on an analysis of all of the probative evidence of record bearing on the likelihood of confusion. The court cites to E.I. DuPont and is going to rely on some of the case law that was set forth in this seminal case. Not all of the DuPont factors are relevant to every case, and only factors of significance to the particular mark need to be considered. For example, the board can focus on dispositive factors such as similarity of marks and relatedness of goods. The fame of the prior mark can be critical. These factors and the other relevant DuPont factors are discussed below. Fame of the prior mark. We begin with the fame of a poser's Margaritaville mark. Fame of the prior mark, if it exists, plays a dominant role in balancing the likelihood of confusion factors. Fame for likelihood of confusion purposes and fame for dilution purposes are distinct concepts. Unlike dilution, fame for likelihood of confusion purposes does not require the opposer to show fame among every segment of the U.S. population. Rather, fame for likelihood of confusion purposes arises as long as a significant portion of the relevant consuming public recognizes the mark as a source indicator. Fame for likelihood of confusion purposes may be measured indirectly by the volume of sales and advertising expenditures of the goods sold under the mark, for example, and other factors such as the length of time and use of the mark, widespread critical assessments, notice by independent sources of the products identified by the marks, and the general reputation of the products and services. Jimmy Buffett, the original owner of Opposer's pleated marks, explains the genesis of the Margaritaville brand for clothing and retail stores featuring clothing in his declaration. In 1977, Jimmy Buffett, released the song Margaritaville. The song Margaritaville appeared on an album. I have performed it in my concerts. It is a term I coined to describe a fictional location. I regularly refer to Margaritaville as a state of mind inspired by margaritas. I mean, that right there, that has got to be one of the coolest lines I've seen in a court case. I regularly refer to Margaritaville as a state of mind inspired by margaritas. The images I most commonly associate with Margaritaville are beaches, tropics, leisure activities, and islands and escapism. In 2016, my song Margaritaville was introduced into the Grammy Hall of Fame. Based on the success of my song and the loyalty of my fan base, in 1985 I opened a retail store named Margaritaville in Key West, Florida. In addition to selling Margaritaville branded souvenirs, and including clothing in Key West, Florida, this retail store mailed newsletters named The Coconut Telegraph to my fans to purchase Margaritaville branded souvenirs, including clothing by mail and phone. What the Trademark Trial and Appeals Board here is doing is going over all of the fame and the basis for the fame of the mark, in case you're just joining us. Thus, the record shows that Opposer, through his precedent and interest, through its predecessor in interest, has continuously used the Margaritaville mark for over 30 years to identify clothing items and retail stores featuring clothing, and that the mark has its origins in a well-known song by Jimmy Buffett, symbolic of a state of mind. By 2013, I could use a macaw, Sarah. By 2013, Opposer and its licenses had expanded its Margaritaville branded retail stores to 14 locations in the United States. Opposer's revenues from the merchandise sold in its stores are of record but are designated confidential. Suffice to say, the figures are impressive. Although the stores sell a wide variety of goods, at least half of the revenues are derived from clothing and headwear sales. From 1985 to 2013, Opposer and its predecessors in interest published a magazine entitled The Coconut Telegraph to promote the sale of Margaritaville branded clothing. Operated an online retail store since 1999. And through its social media platforms, Margaritaville has 677,000 followers on Facebook, 12,600 followers on Twitter, and 58,000 followers on Instagram. In terms of direct evidence of consumer recognition, in 2010, Opposer commissioned a brand awareness survey showing that of 841 respondents, 73% were familiar with the Margaritaville brand. While the survey is 7 years old, it is entitled to some probative weight insofar as it was commissioned prior to the instant litigation and was used in the ordinary course of business. In addition, Opposer has presented strong evidence of unsolicited media recognition of the Margaritaville trademark in connection with the clothing reminiscent of the Margaritaville lifestyle embodied in the song and the retail stores for such items. From the New York Times, Mr. Buffett, patron saint of the untroubled, has long been known for his business acumen. In some ways, with his approach to concert merchandise and tour sponsorship in the 1980s, he created the model of musician as entrepreneur that managers for artists like Madonna and Dave Matthews have pursued more recently. In Billboard, one of the most successful business side ventures initiated by a recording artist is thriving in the 48 contiguous states. That's where Jimmy Buffett lives when he's not slumming in his other pads. And Key West is where Buffett's Margaritaville store has been doing business in Buffett memorabilia and trivia. From Forbes, business savvy sure runs in the family. Warren Buffett's distant relative, writer and singer-songwriter, Caribbean rock songs, Jimmy Buffett has found almost as many ways to capitalize on his particular talent as Uncle Warren has. In Playboy, in the years since, Buffett's many albums have created their own sort of legendary geography, an elusive mythical place where the capital is Margaritaville, etc., etc. The Margaritaville trademark has also been the subject of numerous non-fiction books as an example of successful marketing of lifestyle brands. And then it goes on to cite Thank You for Firing Me, Brand Like a Rock Star, Create Breakthrough Products, Music Marketing for the DIY Musician. It also appears in works of nonfiction as representing a state of mind that says, kick back on the front porch, chill out, have a beer, gaze mindlessly at the tropical surroundings. Anything that is a problem will have to wait until tomorrow because right now I'm enjoying my own little paradise. As illustrated below, the trademark Margaritaville is closely associated with a particular brand of clothing, style of clothing. He pretended to check the merchandise in Margaritaville's store. Instead, he eyed the passing crowd, examining the... Excuse me, I'm having some trouble speaking right now. Instead, he eyed the passing crowd, examining the people for familiar faces. Nothing. Don't you just love Jimmy Buffett? Kyle looked down at the cute brunette at his elbow. The mogul of margaritas is my kind of guy. Remember, Margaritaville is just a state of mind, not a place. Actress. They're filming a movie. Here in the casino, Vampires in Vegas. Really? That's exciting, the one wearing a Margaritaville t-shirt said. He didn't seem to. No like when he saw Charlene. Danny pulled into the drive beside the building, the goat man, in jeans and a faded Margaritaville t-shirt, with a broad-rimmed straw hat on his gray hair, was sitting outside the clinic on a bench. From Trick My Truck, but Don't Mess With My Heart. You seriously need Stacy and Clinton to clean out your closet? Sarah says, why holding up my prized Jimmy Buffett Margaritaville t-shirt and tosses it to me. Do you actually wear this stuff? Hey, I'm a parrot head and proud of it, I tell her, referring to what a huge Jimmy Buffett fans are called, me being one of them. Fine, he said. He tucked in his Margaritaville shirt, felt the back of his shorts for his wallet, and awaited his orders from the Sarge, but they never came. Actually, I think I was reading that wrong, though the titles were above. So that was The Telltale Turtle, was the one that I liked above. These excerpts show that Opposer's Margaritaville marks have been the subject of widespread media and popular culture. Opposer has established that its pleated Margaritaville mark is, for purposes of likelihood of confusion analysis, famous for clothing, namely shirts, sweatshirts, sun visors and caps, retail clothing, gift and souvenir stores. The goods and trade channels is the next section. The next step in our analysis is a comparison of the goods identified in applicant's application vis-a-vis the goods identified in Opposer's pleaded registrations. At the outset, we note that the involved applications and Opposer's pleaded registrations include goods and services that are identical, at least in part. Two applications both include sweatshirts, both include retail clothing stores. Given that the goods and services are identical in part, in each of these consolidated proceedings, this DuPont factor weighs in favor of finding a likelihood of confusion. Because the goods and services are legally identical in part, and neither Opposer's registrations nor the involved applications contain any limitations on the channels of trade and classes of purchasers, we must presume that the channels of trade and classes of purchasers are the same for these identical goods and services. For this reason, applicant's argument that she intends to market and offer her goods and services solely in locations that support the marijuana industry is unpersuasive. As such, the DuPont factor regarding similarity or dissimilarity of the established, likely to continue trade channels also favors a finding of likelihood of confusion. Another factor is the conditions of sale, another of the DuPont factors. Next, we consider the conditions under which the goods and services are likely to be purchased, whether on impulse or after careful consideration, as well as the degree, if any, of sophistication of the consumers. Purchaser sophistication or degree of care may tend to minimize likelihood of confusion. Conversely, impulse purchases of inexpensive items tend to have the opposite effect. If you're just joining us, we're talking about trademarks and the likelihood of confusion between Jimmy Buffett's Margaritaville and this private person, individual who registered Marijuanaville. And so far we've gone over that they want to sell basically the same things. They want to sell merchandise, and they want to sell items in retail stores and restaurants and things like that. And the court has said that there are several factors that we go over called the DuPont factors for establishing whether one trademark is confusing with another trademark. And so we're going over, I think this is the third condition, the conditions of sale. Applicant contends that it intends to direct its goods and services to consumers connected with the cannabis industry, and therefore confusion as to the source is unlikely to occur. But the identifications in the applications of Opposer's registrations, so Margaritaville, do not include any limitations regarding marketing. Nor do the applications of the Marijuanaville trademark contain any limitations due to marketing. When you register a mark, you can specify that it only applies to certain things or only certain words of the mark you're claiming ownership to, and this is unlimited, basically. In addition, they both include retail clothing stores and apparel offered at no specific price point. We cannot assume, as applicant, Marijuanaville, urges that these goods and services are rendered to different classes of buyers in different marketing contexts and at different prices. Rather, we must presume that the goods and services are marketed to all ordinary consumers of clothing in the usual marketing channels. Ordinary consumers of apparel are likely to exercise only ordinary care, and given the lack of price restrictions in the identifications, may buy inexpensive clothing items on impulse. Accordingly, this factor also favors a likelihood of confusion. The marks themselves is another factor, keeping in mind that where the goods and services are identical, the degree of similarity between the marks necessary to support a determination that confusion is likely declines. We now consider the first DuPont likelihood of confusion factor, which involves an analysis of the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. The proper test is not a side-by-side comparison of the marks, but instead whether the marks are sufficiently similar in terms of their commercial impression, such that persons who encounter the marks would be likely to assume a connection between the parties. So this is where they're going to try and understand what the consumer what their impression may be when they see the marks, and is there going to be some confusion. The focus is on the recollection of the average purchaser, who normally retains a general rather than a specific impression of trademarks. Our analysis cannot be predicated on a dissection of the involved marks. Rather, we are obliged to consider the marks in their entireties. It is axiomatic that a mark should not be dissected and considered piecemeal. Rather, it must be considered as a whole in determining the likelihood of confusion. Nevertheless, there is nothing improper in stating that, for rational reasons, more or less weight has been given to a particular feature of a mark, provided the ultimate conclusion rests on a consideration of the marks in their entireties. Excuse me. Applicant argues that the marks in question, applicant is Marijuanaville, applicant argues that the marks in question, Margaritaville and Marijuanaville, are completely different. You buy that? I don't buy that. As the prefix margarita denotes a mixed cocktail, whereas marijuana constitutes a plant. I see this a lot. Just because you can make an argument doesn't make it a good one. This is like the cargo cult science of critical thinking. Wow, I see this an awful lot. Let me just keep going, or I'm going to start ranting. Opposer, however, argues that the marks are similar in sound, appearance, connotation, and commercial impression. In support thereof, opposer has submitted the declaration of David K. Barnhart, an expert lexicographer and linguistic consultant. He was tasked with evaluating the linguistic status of the term Margaritaville and Marijuanaville as brand names for retail stores and apparel. In this regard, he consulted a broad cross-section of reference books, including dictionaries, thesauruses, encyclopedias, word counts, and handbooks of usage, and surveyed examples of usage from independently collected evidence of the use of the term Margaritaville and Marijuanaville. Ultimately, he offered the opinion that due to the shared linguistic properties of the two terms, when used in the contexts enumerated above, these two terms are similar and may result in consumer confusion. The issue of likelihood of confusion is the ultimate conclusion of law to be decided by the board. Further, the board has consistently held that although opinion testimony on the question of likelihood of confusion is admissible, it is entitled to little or no weight. So the board is saying that just because he's concluded that doesn't mean that they're going to automatically find in favor of that conclusion. For this reason, we cannot, as opposer urges, rely on his opinion testimony, the lexicographer's opinion testimony. The board also generally does not rely on linguistic experts to explain how a mark is pronounced. We can, however, rely on the evidentiary materials made of record to his declaration in reaching our own determination. Turning now to our comparison of the marks Margaritaville and Marijuanaville in terms of sound and appearance, both marks are similar insofar as they are single-term, 14-letter marks comprised of 5 syllables, each commencing with the same letter string mar and ending with the suffix ville. As to their connotation and commercial impression, the record shows a public association between the two terms as representing a similar state of mind induced by either a cocktail or marijuana. According to the record, the suffix ville is a slang term frequently combined with other words to denote a state of being. And the court cites to the World Book Dictionary, ville combining form, U.S. slang. In a state of being in or form. He's Despairsville. See, he's fed up with humanity. I just finished a book, and all I can say is it is like War and Peaceville. Margarita and marijuana are defined as follows. The term margarita, designated as a cocktail, is a well-established, being attested in print from at least as early as 1950. The term marijuana, designating a plant with addictive properties, is well-established, being attested in print at least as early as 1918. Thus, combining margarita and marijuana with ville results in coined marks connotating a state of being associated with either a cocktail or marijuana. A poser also made of record the following evidence showing popular culture and media usage of the term Marijuanaville as an allusion to Margaritaville. Quote, in 1998, Orlando Sentinel columnist George Diaz wrote, "Plug in the Jimmy Buffett CD, everybody sing along to that catchy tune, Wasted Away Again in Marijuanaville, in honor of pinhead Chris Webber, the erstwhile whiz kid who became Sacramento's headache in the off-season, was detained for possession of marijuana in Puerto Rico earlier this week." In 1998, Scott McCabe of The Examiner wrote in his Stupid Crimes column, "Wasted Away Again in Marijuanaville, a Florida Keys teen was arrested after deputies say he left his MySpace page called up on a computer at home that had been burglarized." Oh, that was smart. Deputies found no one inside, but they did find an empty soda and snack containers, some marijuana on a coffee table. In 2015, Five Seasons South Florida should decriminalize street pot. Columnist Daniel Vasquez wrote, "Think Marijuanaville. Tourists would prefer getting high in the sun and surf. Hunger-inducing weed will drive people to local clubs, bars, and restaurants. Along with Margaritaville in Florida, we could have Marijuanaville." In 2014, in a blog post titled Perfect Names for the 6 New California States, one of them was Marijuanaville, the honorable mention. Like Margaritaville, but with more Buffets and less Buffett. More buffets and less Buffets. Singer, songwriter, comedian Mark Eddy has co-written and performs a tribute song called Marijuanaville. YouTube videos featuring the song have over 2 million views. And then the TTAB, then the TTAB puts up, I think this is Twitter. This is either Twitter or, this is Twitter. The connection between Margaritaville and Marijuanaville is also reflected on social media platform Twitter, showing a connection between the two terms among members of the general public. Later today, I'm heading down to Margaritaville. Is there also a Marijuanaville? 2 places I want to visit, Margaritaville and Marijuanaville. It's always 5 o'clock in Margaritaville. Is it always 4:20 in Marijuanaville? Some of my favorite places include Margaritaville and Marijuanaville. Thus, the overall connection and commercial impression of the marks is highly similar, a chemically induced mental paradise. The public is likely to perceive applicant's mark as an extension of a poser's lifestyle brand. Based on this evidence, we find that a poser's mark Margaritaville and applicant's mark Marijuanaville are similar in connotation and commercial impression. In sum, this first DuPont factor regarding the sound, appearance, connotation, and commercial impression of the involved marks taken in their entireties weighs in favor of finding a likelihood of confusion as well. The number and nature of similar marks in use on similar goods. We now consider the number and nature of the marks used on similar goods, the sixth DuPont factor. I'm assuming this has something to do with if it's more of a generic mark and not such a exclusive mark. In other words, so you may have there are a few trademarked terms that have actually lost their trademark over the years because they got used a lot, and then the companies never actually policed the marks and made people stop using them. I think Kleenex was one of them, to refer to a tissue. I don't know if Xerox lost theirs to refer to copying. But some of those get very close, if not cross the line, into being lost because of dilution. I think this might have something to do with that. We now consider, applicant essentially contends that a poser cannot monopolize the commonly shared suffix ville, derived from the French word for town. Applicant, however, has submitted no evidence regarding either third-party use or registration of opposer's mark Margaritaville for the same or similar goods or services. See Palm Bay, another case. The purpose of defendant introducing third-party usage is to show that customers have become so conditioned by a plethora of such similar marks that customers have been educated to distinguish between them. So, since our applicant, the recipient of the applicant is Marijuanaville, since Marijuanaville did not submit any evidence, the Trademark Trials and Appeals Board doesn't have any evidence to go on showing that there are other products out there using a Margaritaville-like mark and getting away with it. As Opposer correctly notes, its mark is a coined term, arbitrary in relation to the goods and services, making it inherently strong. Thank you for the $2, Nick G. In determining the strength of the mark, we consider both its inherent strength based on the nature of the mark itself and its commercial strength based on the marketplace recognition value of the mark. Accordingly, this DuPont factor favors a finding of likelihood and confusion. We turn to the seventh DuPont factor, actual confusion and contemporaneous use. And the related eighth factor, extent of the opportunity for actual confusion, as argued by the opposer. As opposer correctly observes, the current filing basis for both of the involved applicants is intent to use, and we have no evidence that applicant has used its applied mark for or in commerce. Actual confusion cannot yet occur, and evidence of actual confusion cannot yet exist. These DuPont factors are neutral. The ninth DuPont factor, the variety of the goods. Opposer argues that both parties agree that opposer sells a wide variety of goods in multiple retail channels. However, because our finding of fame is limited to clothing and retail clothing stores, we deem this factor neutral in our DuPont analysis. What? Okay. I think they're just limiting it to... Oh, that's right. They said before they're only focusing on the goods or clothing and retail clothing stores because those two seem strong enough. And if the marks were found to be in conflict on those two, then they didn't have to do the rest of the analysis. So I'm guessing they didn't do the rest of the analysis. Market interface. Opposer also discusses the 10th DuPont factor, the market interface between applicant and the owner of a prior mark. This DuPont factor consists of a mere consent to register or use, agreement provisions designated to preclude confusion, limitations on continued use of the mark by each party, assignment of the mark, application, registration, goodwill of the related businesses, and or time or legally bound reasons called latches or estoppel attributable to the owner of a prior mark that indicate a lack of confusion. Latches or estoppel would be like if the owner of the prior mark stopped using it for a while or didn't enforce things for a while, and you came in and did your thing while they were doing that, and you think that you should be able to continue. According to the record, there is no market interface between applicant and opposer. In other words, opposer has not consented to applicant's use. The 10th DuPont factor, therefore, favors a finding of likelihood of confusion. The next DuPont factor raised by opposer is the extent to which applicant has a right to exclude others' use of its mark on its goods. There is no evidence that Bevis, the applicant for Marijuanaville, has any right to exclude others from using Marijuanaville except for any rights based on the applications, which are opposed in this proceeding. For this reason, the 11th DuPont factor favors a likelihood of confusion. So this is talking about if you've established any non-USPTO trademark rights, which do exist. And if you started selling something in your state locally under a name or something, you'd have some basic trademark rights under your state's law, or the laws of your country most likely. If you don't know what those rights are, you definitely want to speak to an attorney or do some internet searches, because this video is not meant to be any individualized legal advice. Extent of potential confusion. Last, we consider the extent of potential confusion, whether de minimis or substantial. De minimis is literally minimal. Why we can't say, new good words that whatever. With regard to this factor, applicant argues that there is no realistic potential for confusion. Opposer points out that the clothing and retail store goods and services involved are directly competitive. Since these are the types of goods and services that would be marketed to and purchased by significant numbers of purchasers, the potential for confusion there cannot be deemed de minimis. Accordingly, this DuPont factor favors opposer. Balancing the DuPont factors, I don't know if you've been counting, but the vast majority of the DuPont factors have been in favor of opposer, and I think there were 2 or 3 that were just not applicable. So let's see where this goes. The record shows that opposer's mark Margaritaville is famous in connection with clothing and retail stores featuring clothing and is inherently strong. As such, it is entitled to a wide scope of protection. Famous marks are accorded more protection precisely because they are more likely to be remembered and associated in the public mind than a weaker mark. The goods and services involved are identical in part and are therefore presumed to travel through the same trade channels and be purchased by the same classes of consumers, ordinary consumers. Ordinary consumers of apparel are likely to exercise only ordinary care in determining the source of their goods and may buy inexpensive clothing items on impulse. When considered in their entireties, the marks Margaritaville and Marijuanaville are similar in appearance, sound, meaning, and commercial impression. In a correct assessment of the DuPont factors, the fame of opposer's Margaritaville mark magnifies these similarities. A potential consumer who is aware of an opposer's famous mark is even more likely to be attuned to its similarity to applicant's mark upon encountering the latter. The remaining DuPont factors discussed either favor a finding of likelihood of confusion or are neutral. Accordingly, we find that opposer has proved its Section 2D claim by preponderance of the evidence in both proceedings. The opposition is sustained. So I think that's it. There's an appendix with some things, and a list of declarations and all that. So sorry, guys. Without the permission of Jimmy Buffett and Margaritaville, it sounds like we're not getting any Marijuanaville. In fact, if anything, I bet you, thank you, Gizensha Fox. Let me know if I've pronounced that wrong. It sounds like, for the $5 donation. Thank you, Gizensha, for the $5 donation. Is that francs? No, that's British pounds? Geez, I don't even know my world currency off the top of my head. So I guess the best option or best opportunity we've got to get a Marijuanaville is going to be only if Jimmy Buffett partners with somebody and or gives some kind of permission. I'm going to assume that means either doing it directly through the organization that they've got now, or licensing it to someone who probably pays them a very large amount of money or a very nice cut of the profits in order to do something like that. Okay, everyone, thank you so much for your contributions, for your chat messages, for your time and your attention, your interest in the law, and your subscription to my channel. I'm Leonard French, your favorite copyright attorney, and I think we might end with the same reggae song that we started with. So, mic muted, and